said if there is no criminal offence, there can be no civil liability.
What was the reference? That was
121B.
Is it your submission that the subsection is geared primarily to the occupier or exclusively to the occupier?
Exclusively. It's not relating. The only person who is who makes offence against for Section 29(1) is the occupier of the premises. Qua occupier.
If an independent contractor renders a place of work unsafe by his activity within it, he doesn't come within the embrace of Section 29?
No.
Why not?
Because the Act says that, he himself, it's the working place which has to be safe, and it is dealing as working place. If any workman, or I think he commits an offence, there are provisions under the Act, I can't remember where it is, they themselves can be found guilty of an offence.
Well, I'm sure there are, but I can't see from the text of the subsection why someone, such as an independent contractor, who causes the place or the means of access to the place to be unsafe, why he should not be liable.
He should not be liable.
Why not?
Firstly, he's not an occupier, and Section 155 imposes the obligation on the occupier.
It's Section 155 that's the key, isn't it?
Yes.
I mean, that's the answer to my Lord's question.
Yes, exactly.
And if so long as there's a criminal offence, then there is a duty, is there?
Well,
even if it's an absolute offence?
By implication, anyone who has been injured has a right of action. It's a breach of statutory duty, and the injured
even if it's an absolute duty?
Yes. Yes.
Is this point discussed in the courts below?
No. I don't think it's actually in any of the skeleton arguments.
Is that because the point wasn't?
It's because
You've even just thought of it, Mr.
Yes, yesterday during the submission.
I'm not saying there's anything wrong with that.
But I do believe, having thought about it carefully overnight, that it is a fundamental point that should have been taken before. And it goes to the very
we all
heart.
know the best points are thought of in Middle Temple Lane after the case.
Yes, indeed. It has a number of very important results in this case, because the occupier may have no knowledge of any idiosyncrasies or susceptibilities of any individual workman. And consequently, the standard of safety that he is required by Section 29(1) to achieve must be set by reference to the workplace, not by reference to the workman. And in view of the fact that a breach of the section results in a criminal sanction, that standard of safety must be by reference to current standards of safety relevant to the date of the breach.
So can you just explain the proposition that you've just advanced, the one immediately before that, the most recent one, namely that the occupier may not know of the susceptibilities, and therefore the standard must be set by reference to the workplace and not the workman. I mean, Section 29(1) says it must be made and kept safe for any person working there.
Yes.
So
the place of work
Yeah.
has to be safe for any person working there. You don't know who's going to be working
Yeah.
there. It could be an independent contractor, it could
Yes.
be an employee of his, it could be an employee of someone else.
So you say that that's a sort of disembodied person.
Indeed. The standard he has to reach is that he has to have in mind anybody going along with us will be safe. So it's got to be a safe place to work. And in the context of this case, therefore, the level of noise, if noise applies, in our submission, noise does not come within Section 9, but if noise were to come within Section 29, it would be at such level of noise that it could again be unsafe for anyone working there. Whether he was an independent contractor, an employee, or an employer of someone else's. And that, clearly, has been set by the Code of Practice as anything in excess of 90 dBA. And indeed... Sorry,
It is quite irrelevant, therefore, that the occupier knows that the people who are working there happen to be particularly susceptible.
Yes, it is, because that is the employer's responsibility. For the purpose of this Act, he has to provide a standard of safety that achieves a certain level, and achieves a level that is appropriate for any person, whether he's an independent contractor, employee of his, or employee of someone else.
I find that a difficult submission. Surely, if you had an institution which focused on supplying job opportunities for particularly susceptible people, that would shape the whole of the duty as regards them as occupiers. And similarly, I mean, if you have an institution like this, which has a perfectly ordinary group of employees, surely they have to, when considering whether the premises are safe as occupiers, take into account the full range of employees who may be occupying the premises, and they may have to take into account that they're likely to be there for more than a week, for example, or they're likely to be, some of them, if this is at any rate reasonably in contemplation, likely to be susceptible to certain types of problem.
No, Lord, I quite agree with what your Lordship's just said. He has to take into account all those relevant factors.
Yes.
And then he has to decide what is the relevant level of safety he's got to achieve for that whole group. But he doesn't have to cater it or alter it to take account of any particular individual at any particular time. And particularly in our case, because he won't know which of the particular individuals are particularly susceptible.
But if he knows that some people are particularly susceptible, then he'd have to have regard to them, wouldn't he? Under Section 29, because it refers to any person.
Yes, but the question whether any person means a particular individual or any person in general.
Well, why doesn't it mean any person in general? Well, any person he can reasonably foresee is going to be there.
Because here we're dealing with occupiers in general. One's looking at a standard that he's got to achieve. If one reads through the Act, it shows various standards, whether it's heating, lighting, place of work, access to place of work, and that he has to reach whatever that standard is appropriate for the particular case. Now, I accept it's the particular factory where he is, the premises that he occupies. He has to take that into account. But he can't, as occupier, not being the employer, he's not going to know who's going to be employed on any particular day. He's not going to know who's going to be sitting at which particular machine. I'm taking it slightly out of the context of the present case. But he won't have the information necessarily that an employer will have. The employer-employee relationship, and indeed duty of care, is its own special duty of care. The employer has a duty to see that his employee is reasonably safe in all respects, including providing a safe place of work. Now, this Act was dealing with the safety of factories as factories. And whoever happened to be there, you owed a duty to them in general. I mean, it was so that, under what Lord Pearson says, if there is a workman who happens to be an independent contractor, exposed to something that is unsafe at the place of work, he has a right in civil remedy against the occupier.
So, I mean, it comes down to this, does it? That you say that the statutory code is dealing with occupiers, qua occupier. You have a standard which is based on safety and qualified by reasonable practicability. If you happen to have special knowledge that a particular employee was vulnerable, then that could affect your duties qua employer, and you would then have to take special duties, probably as a matter of the general law of contract and tort, possibly. There may be statutory.
It's your duty of common law, quite clearly.
Yeah. But there may also be statutory provisions which apply to qua employer. Probably, but we haven't looked at them if there are.
I don't think they're relevant here.
Yeah. Right, well, then common law. But that's the sum of your submission on this.
It
really.
is. It is.
Yes.
It is. And on the and by reason of being a criminal sanction, in our submission, that the standard has to be, he has to know what standard he's got to achieve. And he has to know that at the date of the breach. Because someone who's going to be found guilty of a criminal offence, if what's being said here, the occupiers, where he occupies is actually put against us as employers, were breach of an offence 30 years ago, the breach looked at as at that date has to be by reference to what the current standards of safety were at that date. It can't be looked at as at standards of today. And indeed, my Lord Saville mentioned yesterday, well, what is the relevant date? Well, the relevant date is every date that he commits the offence is a relevant date. But of course it can be a continuing breach day by day on every occasion that he has failed to make the place safe for the particular workman.
If the Act does apply, when does the cause of action accrue?
The cause of action in
tort.
Well, that's an interesting point, because what Lord Pearson says is anybody injured.
I agree it's an interesting point, but what's the answer?
Yes, if you take, let's take a case, not this case, if you take a case where everybody working there is likely to be adversely affected in his or her hearing after, let's say, a year,
Yes.
then I think you would accept as an occupier, since anybody who goes in there is going to be affected after a year, you have a duty to do something about it.
Well, you are in breach of your duty. You are in breach of your duty.
Well, so can we start with, well, you have a duty. You accept you have a duty in such a case.
By implication, you have a duty. The first question, as Lord Guest said, have you committed a criminal offence?
I accept
If you
that,
posit
yes.
you have committed a criminal offence, then the person who is injured may have a right to claim damages from you if he suffers injury. Otherwise, he's only relying on a common law duty, not a statutory duty.
Yes, I follow that.
And if he's relying on his common law duty, you have breached a duty to me, and under common law I therefore have a right to remedy it from you. He has to show that he's actually suffered damage. It's no good his just showing he was put at risk.
Yeah, my question wasn't really directed to that. No, it's my fault, not yours. I was taking out of the equation the fact that only some people who go into a factory with the noise levels in question here are likely to be injured by prolonged noise. If we take the case where the noise level is very much higher than it was in this case, so that you could confidently say that after, and I've taken as an example, after people work there for a year, all would be likely to suffer injury.
I don't think you could ever say that, because the science shows there are some people who are virtually impervious.
Well, I think you probably could say it. If you go up to 120 decibels, you're likely to kill people.
Yes, but there are some people who seem to have absolutely no effect on it, surprisingly. I would accept there will come a eventual time when it was so loud that.
All or virtually all people would be injured,
accept,
yes.
yeah.
Would you accept in those circumstances that the occupier has a duty under Section 29, or would be
No, he
breached?
doesn't have a duty. He doesn't have a duty under Section 29, a statutory duty under Section 29. But if he has allowed that to happen, he's guilty of a criminal offence.
Yes.
And that gives rise to a civil claim by people who actually suffer injury.
Well, coming back to my question, which is puzzling me, when does that occur?
That is when they actually suffer injury.
When they
after the 10
actually
years.
suffer injury?
Yes, because that's like any case of negligence, common law. You do not get a right of action until you've actually suffered injury. Injury is a necessary ingredient to the cause of action.
So that on my perhaps artificial example of a year, no breach is committed until the end of the year.
Breach of criminal law is, but no.
The tort requires the extra ingredient
Yes.
of damage.
Of damage.
Now, why is a criminal offence committed then?
Because you failed to comply with the obligations under the statute. I don't accept the noise comes within it at all.
No, I follow
But if
that.
the noise does come within it, you have failed to make and keep safe the place of work for all those who are working there.
Although, could it not be said that at 9 months, it's still perfectly safe?
No, because you have to judge the safety by the level of noise at the place of work. And a factory inspector could go into the factory without anybody working at any of the machines, and he could say, the level of noise in this factory is at 120. Therefore, it's an unsafe place of work. I'm going to put a closure order on this factory until you do something about it.
And that's regardless of whether any of the people working there actually suffer any injury at all.
Absolutely.
Yeah.
Yes.
No.
And if he was right about that, that would involve the commission of a criminal offence.
It would, indeed.
And the additional ingredient that would be required on Lord Pearson's analysis is that there would have, in order to be able to institute civil proceedings, you'd have to show that you'd suffered damage.
You would.
As a result of the breach.
You would.
I mean, I suppose if you could show the unlikely scenario that the occupier said it's true that these machines are making an incredible racket, but they're only here for 9 months, and medical opinion is that as long as you aren't working in this condition for a year, you won't suffer any damage at all, then he'd be able to say, all right, it's safe.
I think he'd have some difficulty in that one. I don't think it. Fortunately, we haven't got that particular case to.
But you must have situations where you can expose someone for a short time
yes.
to an what would be intolerable over a longer period.
Indeed. As the Code of Practice says, if you expose them for 8 hours a day at above a certain above 90,
yes.
whatever it is, and it goes on long enough,
yes.
then there's likely to be injury. So, yes, that is true. But there won't be injury overnight, no. And
Does Section 29 have an independent life beyond providing the basis for criminal liability under Section 155?
no, it can't.
Well, why not?
But I don't see how it can. I mean, it can't just give rise to a civil right of action in its own. Lord Pearson's approach must be the right one.
Well, ironically, if there were no criminal offence, then it would be easier to argue that Parliament must have intended that there be a right of action. I thought the argument usually was Parliament can't have intended that there was a civil right of action here because it's provided all these criminal sanctions. So there's something a bit odd about Lord Pearson's approach.
Yes.
I mean, it's a decision of the House of Lords and has been held to be correct throughout, but one might have thought a stronger argument was the other way.
Lord Guest says the same.
Well, maybe, but if we ask ourselves what the rationale of their decisions are, I remember Mr. Justice Brandon always said the first question you should ask about any case is it rightly decided? And so, I mean, we ought to know what the basis for Lord Pearson's view is.
The basis for Lord Pearson's view, well, it's the the object of this, the object of the provision of the Factories Act is to improve the standards of safety in factories.
But I can imagine Lord Hoffman saying ringingly that here we have a provision which has all these criminal sanctions. That's what Parliament intended. If it had intended to have a civil, it would have said so.
Well,
at any rate, we have
Lord
Pearson. Nobody said he was wrong.
For interestingly enough, the 1974 Act, which Your Lordship has mentioned several times, does say it only has criminal sanctions and gives rise to no civil liability. But unless I've missed something in this, it doesn't say you can't have civil liability. That point would have been taken many times before.
But my Lord's question, what would be the position if there wasn't Section 155, would be answered, surely, that it would be a very odd piece of legislation which simply asserted this with an intention to create a civil liability, when it's on the face of it not directed to civil liability.
No, it's directed effectively to criminal liability.
It's a statement of duty in the abstract. This doesn't look like a piece of legislation like the Occupiers Liability Act.
No, that would give, I'm grateful to Your Lordship, that would support Lord Pearson's approach, saying it's only by implication.
I don't know that it supports the implication, but never mind, we have Lord Pearson saying there is an implication.
And it would actually duplicate the Occupiers Liability Act, wouldn't it? I mean, if you were intending this as a piece of legislation or a legislative provision, Section 29(1), which gave rise directly to civil liability, you would immediately think, well, how does it relate to the Occupiers Liability Act?
The Occupiers Liability is far
It's quite wider, of course, but I mean, it would be a rather odd specific provision, I suppose.
Yes.
Also, it only provides for the common duty of care, doesn't it, the Occupiers Liability Act?
Yes, it does. Of course, there are two Occupiers Liability Act now. One is a common duty of care under the 57 Act, and the other is a duty of care under the 1984 Act.
Yeah, but considering this at 1961 Act.
Yes.
Yes, well, where do we go next?
Yes, well...
Just before you do, I'm sorry, I'm still slightly puzzled. You say a criminal offence would be committed by an occupier in circumstances like the example I've given you, leaving aside special groups of people with a special susceptibility. If everybody, or virtually everybody, is likely to be injured if they work in a noisy environment for more than a year, that a criminal offence is committed at the outset.
Yes, one would expect that, because it's also prevention rather than paying damages.
Yes.
The idea of these acts is to...
Even if nobody was ever expected to work for more than 6 months? Because then you'd say, well, if nobody was expected to work for more than, say, 6 months, then it's safe.
I think the reality of the situation is the factory inspector probably wouldn't worry about it in that situation.
Your primary argument is surely that this all demonstrates that Section 29(1) isn't aimed at this type of situation
Coming
at all.
right to that, it doesn't deal with noise at all.
Yeah.
No,
It's
that's
really
why we run into terrible problems. It's really dealing with going into a factory, there's something unsafe about the place of the work, the chap gets injured, trips over and has a nasty accident or whatever it is because of the structure, and he has an injury straight away. And that's really what it's aimed at.
A bit falls off the roof or something like that.
Something like that. Yes, or something falls off, or the whole place is clearly unsafe. And when I come to my submissions on that, there are many places of work which one can say were clearly unsafe, and there's no argument about it, and then it's purely a question of reasonable practicability. But it's been used, this section has been used for noise, so that's where we say this is wrong. But,
what about asbestosis?
It's been used has been
Pieces
used.
for the amount?
Yeah, it has been used.
For that.
Yeah.
But that would be inconsistent with your argument, would it?
Sorry?
Would that be consistent or inconsistent with your argument?
Well, I don't think we got the asbestosis case in the bundle. What? Dust is covered by is specifically covered by the and ventilation by provisions in the Act. Yes. That's injurious to health.
Well, that would be interesting to see whether asbestos has been brought in, or asbestosis.
Well, I think they rely on the asbestos regulations.
It's not obviously Section 4.
It's not obviously section, but there is another section.
63.
63.
Ah, yes. Your argument in relation to the first two parts of the Act is the one that my lord's just raised, that part two is dealing with the sort of sudden accidents from the immediate state, and
yes.
part one is dealing with long-term problems. It occurred to me that there was a difficulty about that when one came to find drainage of floors in part six, but it may be that that's dealing with long-term risks of walking around with wet feet.
It could be. It could be.
Rather than slipping risks.
Yes. Yes. But they're all, most of those things are dealing with what you know, cleaning up and making safe the factory, and the responsibility of the occupier.
Well, Section 63 is all about occupiers too, isn't it?
Yes, I think occupiers, apart from where it says owners, apart from where it says parents, it's occupiers.
But not employers.
Not employers. And on the facts of the present case,
Is this a point that's been adverted to in the learning, as it were? The
has it been
academic
adverted in the learning?
Yeah.
Not as far as I know. It might have been, but if Mr. Hendy will certainly be in a position to tell you about that. But on the facts of the present case, Judge Ingalls made certain findings of fact. He said, firstly, the standard to be achieved was a jury question. And turning himself actually into the notional jury, he said the standard for the 70s and 80s was 90 dBA, leaving aside first the special knowledge. Now that in our submission is a finding of fact, not law. And insofar as the Court of Appeal have overruled it, they were wrong to do so and had no justification. But the standard of what is a safe place of work must be the same at common law as it is under statute. And so said Lord Justice Salmon in the case of Paramore. And there is an inconsistency in the Court of Appeal's approach where they appear to have adopted a different standard of safety for the purposes of the statute that they did for the purpose of the common law. But our submission is the standard of safety was the recognised standard of 90 dBA for both statute, that's if noise applies, both statute and common law, leaving aside special knowledge, for the whole of the 70s and 80s. Now, I've already said quite a lot about this, so I go quite quickly to the next section I was going to deal, which was what is the scope of the duty of Section 29.
Is this in your case?
It is in our case, yes.
Which paragraphs are we looking at?
Sorry, yes. That's with paragraph 1 we deal with it.
Yes.
And right the way through to paragraph 11. But just firstly, I've referred to some of the sections which deal with environmental matters. And just for your lordship's note, I can very quickly, I won't take you to them. Cleanliness is section 1.
Sorry, can you say?
Cleanliness is section 1.
Yeah.
Temperature is section 3. Ventilation section 4. Light section 5. Humidity section 68. And they all impose absolute obligations on the occupier. The dangers are also, and these again are mandatory obligations, absolute obligations. There is also machinery, is covered in certain respects. Firstly, prime movers, section 12, transmission machinery, section 13, and all other machinery, section 14. And then there are other special provisions relating to hoists and lifts, section 22 to 23, chains, ropes and tackles, section 26 to 27. They're all absolute duties. And if there's a breach of any of those sections, it's dealt with as a matter of breach of those particular sections, which gives rise to an offence. You don't go to, in our submission, to section 29, which is inappropriate when you've got a specific provision dealing with those particular problems. And floors, passages and stairs are section 28. It's our submission that noise was not included as one of the environmental factors for the specific reason and deliberate reason, as we've set out in our submissions, sections 6 and 8. Not enough was known about noise at that time for it to justify any legislative provision. There were cases brought under the common law against employers where some employees had been injured by extreme levels of noise, but there wasn't anything that enabled the legislation to say what level was the appropriate level. Now, the Wilson, we refer to as paragraph 6, the Wilson Committee, which in July 1963 said we do not consider the present knowledge of this complex problem provides a sufficient basis for legislation. We've also referred in paragraph 8 to the annual report of the Chief Inspector of Factories in 1965. Occupational deafness at present, there is no legislative requirement for the control of noise in factories, nor is occupational deafness prescribed under the National Insurance Industrial Injuries Act. The problem was examined by the Wilson Committee, whose report was published in 1963. They concluded that the knowledge then existing was insufficient to enable legislation to be made. And we refer also to the annual report in 1974, which something fairly similar is said. What had been happening in the meantime was that Mrs. Burns and Robinson had been commissioned to prepare a paper dealing with actual levels of noise and how the authority should deal with it. Their report is at A2, bundle A2, volume 3, that's appendix 2, I think, volume 3, tab 27. They reported in March 1970, and they were commissioned to undertake the exercise in 1961. Now, Mrs. Burns and Professor Burns and Dr. Robinson were the two people who really are the stars throughout this history. They were the people who seemed to know more about noise than anybody else. They were the people who prepared this paper. It came out in 1970. This was the basis of the Code of Practice that came out in 1972. It was also the basis of the MPL tables, which were produced in 1973, and the British Standard that was produced in 1976. It all comes from the work that Burns and Robinson did between 1961 and 1970, and if your lordships wish to read about it, it's very heavy reading, and it doesn't take you very much further at the end of the day. But that is the source of it all. And they carried out a large number of tests and assessments on people who suffered from noise-induced hearing loss. So it's our submission that noise clearly must have been deliberately left out of the Act. and should not now be used, or shouldn't be. The act shouldn't be sort of adopted in order to include in it noise which was never intended to be there in the first place. The way it was dealt with was by two sets of regulations, the agricultural regulations and the tanker cab regulations, both I think were in about 1974. And then, of course, it was overtaken by the Health and Safety at Work Act 1974, which came out as a result of the Robins Committee report, where the duty was put on employers to ensure the health, safety and welfare of all their employees. That's section 2. So that was fundamental and very wide-reaching regulation. And section 3, which said, and in respect to people other than your employees, you must conduct your undertaking so far as reasonably practicable not to expose them to risks to health and safety. And interestingly, but not surprisingly, in respect to people who are not your employees, it doesn't include welfare, just health and safety. And I'll come back to the difference between the two provisions in a moment, but I was first going to deal with what is a safe place of work, because it's our submission that the obligation to provide a safe place of work under Section 29(1) of the Factories Act is the same objective is to be found under the common law duty of care to provide the employee with a safe place of work. Now, in many cases, it will be plainly obvious whether the place of work is safe or dangerous. And that will not be an issue the court has to decide. But there will be cases where it's unclear on which side of the line the case falls. It's our submission that where there is a recognised code of practice, particularly one that has been adopted by the Health and Safety Executive, as was the code of practice in this case, that should be accepted as the appropriate level of safety for all health and safety matters and cases, save in exceptional circumstances where the employer has special knowledge.
Or the occupier.
Well, here I'm now dealing. Sorry, the occupier. Indeed, yes. In the absence of a code of practice, the objective standard of safety, in our submission, may be set by the common practice adopted by reasonable employers, following the approach of Mr. Justice Swanwick in Stokes. That case is at Bundle A5, tab 107. But where there is no code of practice and no common practice, there has to be some way in which some principle on which the court decides whether the place of work is safe or unsafe. And it's our submission that the correct approach is that adopted by Lord Diplock in Taylor and Colite, which is A6, tab 108. And what Lord Diplock, Lord Justice, said,
So, can you give me the reference again?
sorry, it's,
A6 108.
A6 108.
Authorities.
Sorry, yes.
Yes.
Authority bundle
At-
6, bundle 6,
108.
tab 108.
Thank you.
And no, I think I can remember. I'm trying to see exactly where he set out the foreseeability.
319.
319.
Bottom of the page.
Yes, the occupier's duty in respect to a working place is not to prevent accidents occurring to persons working there, but to take such measures as are reasonably practicable to make and keep the working place safe for such purposes. Safe, and this is the point there, is the converse of dangerous. A working place is safe if there is nothing there which, and I emphasise this word, might be a reasonable foreseeable cause of injury to anyone working there, acting in a way in which a human being might reasonably be expected to act. So it's our submission that when Lord Justice Diplock there has used the word might, you have to take into account what was actually there. So it's not a question, you look at the foreseeability test, but you take into account what actually was there. So for instance, in the Lana kind of case, where the whole piece of equipment has collapsed onto the employee, it's no point for the employer to say, I was wholly unaware of that particular danger. Because it was in fact there. The danger was there, and the place of work was a dangerous place of work. So, for the same reason, in Nimmo, where the person was standing on a wobbly bale, it was unsafe. So I think in the case of Ross, where someone is standing on a poorly conditioned ladder, when you look at the circumstances of the case, you can say that was a dangerous place of work. There's no real doubt about it. But the question of foreseeability comes in, where when you've got all the relevant facts in mind, including the circumstances that were in fact there, not just might be there, were those circumstances such as would give rise to a reasonably foreseeable cause of injury to anybody working there, in circumstances which a human being may reasonably be expected to act. So you then apply the foreseeability test, not taking into account the accident which has in fact occurred. It's a foreseeability test that you have to pose to yourself before the accident, not in the light of events, but you do have to take into account the actual condition of the working place.
If Lord Diplock had said a working place is safe if there is nothing there which is a reasonably foreseeable cause of injury, would that have been a different test?
I think that would probably be the same.
So the words
Something.
might be a...
Might be or is.
They don't add anything to the test.
No. So it would be. It can't be that. Can't be that a place is plainly, obviously dangerous is said to be safe merely because the employer was unable to ascertain that danger.
He probably could have rephrased it, might reasonably foreseeably be a cause of injury.
Yes.
I mean, it may just be another way of saying reasonably foreseeable.
Yes. So what we say is you've got to first put yourself in the information of all the factors that are said to have made the place of work dangerous. You've got to look at it in the light of that, and then, knowing those facts, you've got to look at it before the accident and say, would it have been a reasonably foreseeable cause of an accident to anybody acting in a reasonably foreseeable way? So, for instance, if somebody acts in a wholly ridiculous way, is unforeseeable, there is no liability. For instance, I seem to remember there was a case of somebody going up a ladder to catch a pigeon and went round behind the fence that way. And it was held to say, well, that doesn't make the place of work unsafe because he was acting in a wholly unforeseeable way. But this is the approach that was adopted by Lord Diplock in Taylor. It was also the approach adopted I've forgotten it. I was going to say the case of Morrow, which I now can't remember where I lost my note. Yes, the Lord Justice Clerk, this is A8T16, tab 16, by Lord Justice Clerk Ross.
Sorry, just give us again.
A8,
Yes.
tab 6. I'm beginning to run out of my allotted time, so sorry. Tab 16, which was where the claimant had slipped on a small pile of cardboard sheets. And they went through, they adopted Taylor.
So sorry, I think that reference can be quite right.
Oh, well, I've got A8, tab 16.
A8, tab 6.
Sorry.
Morrow.
Morrow, yeah.
So it's Ross, Lord Justice Clerk Ross, where?
And Lord Justice Clerk Ross, the other two were Lord Dunpark and Lord Brand. And it's Lord Justice Ross, I think it's 701 C2E.
Could I just ask you about this word safe? Take a completely different context. Cigarettes,
Yes.
smoking. Were cigarettes safe 50 years ago or before the work done by Pito and so on? Were they safe then?
You can say that, because of where you're putting the standard of safety. But if you're asking an occupier whether or not he should allow people to be smoking on his premises, then you have to look at the standard of safety at that date.
Now, I'm taking it out of this context altogether for the moment, just looking at the word safe. I mean, we all now know that cigarettes are very unsafe.
Well, they were at risk of their health. But if you're looking at the question of safe today, you would probably take a different approach. You're looking at it 30 years ago. So whether it was safe at that time has to be judged by the standards of that day.
In other words, whether they were believed to be safe.
Indeed. Well, it has
But
to be,
that is a gloss on
well,
the notion of safety.
well, it's safety by the then standards of safe.
But they weren't safe 50 years ago. They were believed to be safe.
But Lord, this applies to every aspect of work. It's like the highway code, 30 miles an hour. It sort of many years ago, it would be a totally different approach to what we do today. But, and as Lord Hope said in Chargot, this is it's not trying to provide a completely safe place of environment.
But it's not changing standards so much. I mean, 30 miles an hour was understood to be 30 miles an hour 50 years ago as it is today. Maybe standards have tightened up, but the safety of driving at 30 miles an hour is as it always has been. But the safety of cigarettes is surely rather different because 50 years ago, nobody had the scientific knowledge that they now have about the injurious effects of smoke to people's health.
I can see that.
It may be your answer to my question may be, well, you've got to interpret the word safe in the context of Section 29, and it's not helpful to look at the word safe in a different context. But I'm just troubled about the meaning of the word safe and how it can be affected by what people reasonably understand about safety.
Well, I think it must be, because if one thinks one here is dealing with a criminal standard, it's being set, you shall provide your workmen with a safe place of work. Now, whatever principle you use for safety, it has to be by reference to safety as it was then understood at that time.
Well,
Isn't that the point that my lord was really putting to?
Yeah.
I mean, I will, to discuss the meaning of a word in the abstract is not helpful. And when you're talking about cigarettes, my lord has obviously a very good point. Similarly, when cars are recalled because something's discovered, they were always unsafe. They didn't suddenly become unsafe on the discovery of the defect, one would have thought. But when you're expecting people to do things,
Yes.
maybe then, in that context, ensure safety simply by implication means ensure what people regard as safety.
Yes.
But it may be different if there's another let out, like reasonable practicability, as there is here. It may be that all the work is done by that let out rather than by implying something into the words ensure safety.
Well, here, in our case, it's to deal with acceptable standards of safety.
Well, you're slightly
because there is a
begging
risk.
the question. I mean,
Yes.
if it stood by itself, then you don't expect people normally to do something which they can't know about and they can't know they ought to do anything about. But if there is another let out, like reasonable practicability, it may be that's where the work is done and where the mitigation of the stringency exists.
I prefer to take my standard on
Of course.
safety has to be assessed by reference to acceptable standards, and the acceptable standards are those appropriate to the date of the alleged breach.
Yeah, I mean, but it is, and we have to divide the section up into bits because of the differing onus, but it
Yes.
could be argued that it's one of these situations where actually it's a bit unrealistic to do so, and you should look at the overall package.
Yes, I think one does have to look at the overall package, although once it divides it up in two. Lord Newberry in one case said if you divide things into two parts of a section to two, you can arrive at the wrong decision at the end of the day. There's a danger in doing that. But safety is a relative term. In our submission, safety varies according to the circumstances. For instance, it's rather a trite comment to make, but safety of a person on the pavement is judged by different standards to the safety of a person on a tightrope. You can't use one meaning of the word safe. Safe has to be taken in the context of the particular situation, and in our submission, in the context of the particular statute, and in the context of the particular time that you are talking about. Those are all facts and matters which go to the conclusion, was this at that time a safe place of work within the meaning of the statute? And so it must be by the then standards, not by today's standards in the light of hindsight.
Well, you appear to have the support of Lord Justice Diplock, anyway.
Yes, I can't. There are a number of cases my learned junior has. I won't take you to them, but if I can just give you a note that where it says you don't take into account for the purpose of interpretation events and with the benefit of hindsight, and she has written down here Thompson and Smith ship repairers A7 tab 110, Maguire and Holland and Wolf A4 70, Harris for BRB A 10. I'm not sure. Stokes for DK.
Sorry, what was Harris?
Well, I'm not quite sure what's that.
I think we've seen it yesterday.
Yes, I think, yeah, I have to reply that later. Stokes and GKN A6107, and Taylor and Fazakali A6109. Could I very briefly say something about, I won't take you to it. In our submission, well, first I have to deal with Allen very quickly. Case of Allen and Avon Rubber, which is the case where Lord Justice Stocker approved the Diplock approach and said that was always the approach that had been applied, as far as he knew, for the purposes of Section 629.
I'm sorry, the reference?
I've got it written somewhere. I'm trying to get... What? A1 tab 2.
3.
Tab 3?
2, sorry.
A1 tab 2. That was a case where a person was on a forklift truck, the employee was on a forklift truck, working on a wide loading bay, and the loading bay had a shear drop of about 4 or 5 feet on one side. And the general view was that it was a perfectly safe place for a person who is a skilled forklift driver to be working on such a loading bay, even though there was a drop of 4 feet shear drop on one side. But on the day of his accident, he had actually been required to carry out work within a few feet, very close to that particular fall-off point. And because he got distracted, he unfortunately put the forklift truck into reverse, and over he went down the sheer drop. Now, Lord Justice Stocker cited the Taylor and Colite test with approval, so it's all a question of foreseeability. And normally it would be a perfectly safe place of work for this particular forklift truck driver, but because he was asked to work so close to the edge of the loading bay, it effectively became an unsafe place of work. And so he succeeded. Now, that case was cited by Lord Gough in Austin Rover, and Lord Gough criticised it. But our submission, the criticism by Lord Gough, and I say with the greatest possible respect, was not appropriate, because Lord Gough criticised Allen on the basis that a dangerous place became safe when the danger was unforeseeable. That is not what Alan Avon is saying. What their lordship said in Allen case was the foreseeability of the risk of injury, because the sheer drop was so close. That's what made the place unsafe. Although it would have been safe if he hadn't been required so close to work so close to the drop-off point. So, I'm just saying that Lord Gough's criticism is not appropriate. None of their other lordships agreed with it, or they didn't concur with his speech. And Lady Justice Smith in the court below, in this case, didn't think it appropriate to take Lord Gough's comments into account when considering place of work. And it may be for the same reason that I've just outlined to your lordship. Common law liability. I didn't think I really wish to add much on that. We've made our submissions about special knowledge in our case, which dealt with that from paragraph 64 through to, it goes all the way through, I think, to paragraph 80. It does it in considerable detail there. We're saying there was no special knowledge on the facts of this case. The state of knowledge remained the same throughout. And even if we'd made further inquiries, we couldn't have discovered more than Burns and Robinson had discovered by their own assessments and reported to in their own paper. So even if we had carried out further investigations, we would arrive back at the risk is as stated in the Code of Practice. So it wouldn't have revealed anything more. So the learned judge in our submission was wrong, Judge Ingalls, to say that Courtaulds had any special knowledge. He didn't define what the special knowledge was. He says of the route we could have taken by carrying out further investigations, but he didn't say what that would have revealed, in addition to what we already knew. And our submission, there was nothing else to be found out. The state of knowledge then is the same as the state of knowledge now. The only thing that has changed over the course of the period between then and now is that the approach to safety by the Europeans has changed, and so the levels have somewhat changed. But the actual level of safety has not changed. And we've also dealt in some detail with
The special knowledge, would it be right to say it seems to be based on the idea that the general perception resulting from Burns and Robinson was that 90 isn't acceptable?
Yes.
But if you'd really read Burns and Robinson closely, or if you had actually looked at some other material, the British Standard, then you would realise that it wasn't, or shouldn't be.
It can't be right, because Burns and Robinson, having been read in complete detail, then brought about the Code of Practice. And two of the people who were responsible for the Code of Practice were Burns and Robinson. They were the authors of the Code of Practice. They also, I can't remember, the NPL tables, I'm not quite sure they were actually involved in that, but they may have been. But they were the authors of the Code of Practice. And the Code of Practice was still, never been withdrawn right up to the start of in January 1990, when the new regulations came into force. It still remained the Code of Practice.
You're challenging, can we just look at the judge's finding in relation to your clients then?
Yes, I think it's paragraph 56. It's the last 5 or 6 lines. He's just saying no large company who responded to the consultation documents and read the background documents was aware of the EEC proposals, of course has done all of that. And one that took part in the debates trying to fend off the compulsory protection at 85 on economic grounds, but not on grounds that such levels of exposure were not harmful, could be said to be ignorant of the facts by the beginning of 1983 at latest. Well,
And what are the facts?
the facts are the facts that they've always been, that 90 is the generally accepted maximum level of acceptability, but it doesn't guarantee that people exposed to levels below that will not suffer injury. But you can't identify who those people are. And that was what was clearly stated in the Code of Practice.
But it's actually, if you look 7 lines up, the sentence, there was a clear awareness by the early 1980s that exposure to levels of noise between 85 and 90 could be expected to damage the hearing of some workers to the extent that action was desirable at those levels.
Yes.
If that were taken literally, it ought to mean that no one could rely on the Code and Practice anymore.
Indeed.
Because by now the general climate of acceptability had changed. But it obviously doesn't mean that. It means that courtholes should have subscribed to a view which was beginning to gain some credence among, but hadn't gained general credence.
What it's really saying, we should have put into existence the scheme that we probably realised or thought was going to come about as a result of the further directives from the Europeans. But the fact that we in fact did start to take some steps to move towards that. But the fact that we were doing that shouldn't in any way change the standard of care that we were required to follow according to the law.
Well, the law is to take all reasonable care, and if there was a clear awareness by the early 1980s that exposure of levels could be expected to damage, not just reasonably foreseeable, but could be expected to damage the hearing of some workers, then reasonable care requires taking some precautions. That's the argument, I imagine.
Well, yes, but that was exactly what was said in the Code of Practice.
And that applies to everybody, not just you.
Yeah, it applies to everybody, but that's in the Code of Practice. The Code of Practice says maximum acceptable level 90.
But how could it say that consistently with this conclusion?
Well, it says desirable. It says desirable. Well, because it has to weigh.
People, they know that some people are going to be injured if you don't reduce the level to 85, or if you don't provide some precaution.
Yes. You have to weigh up all the factors, and there is a document I haven't got time to go into, but maybe you might know, called Framing Noise Legislation, issued in 1975, which came in after the Code of Practice, when they were considering what legislation they might be able to bring in. deal with this. And they refer to all these factors. And the Code of Practice has balanced everything. It has taken into account all the Burns and Robinson research. What level of noise results in what kind of degree of hearing loss over what period of time. It also takes into account the ordinary hearing loss that people suffer as they get old. There is some science to say that when you get up to about the age 60, 65, your natural hearing loss actually subsumes any noise-induced hearing loss you'd ever suffered in the past. So there are so many factors to be taken into account. It's not a simple equation of saying there are going to be some people who suffer injury, therefore you have to lower the standard to that level. And that is one of the base points of the case, because the Court of Appeal said you do, effectively. You've got to go down to the lowest level and deal with the most susceptible employee. That's where the standard should be drawn. But in our submission, that's wrong. But there was no special knowledge, and as I understand Mr. Henley's submissions before your lordships, all employers are in the same boat. That we're all should be considered as average employers. And we have always agreed with Mr. Henley on that point, that there was no special knowledge to be had, and that the knowledge has always been the same. I'm not sure if I've actually just mentioned to your lordship, on reasonable practicability, we have made our submissions 42, sections 42 to 48, and we set them out in full. Our submission is it has to be carried out foreseeably. It can't be gross disproportion. That where those words were used by Lord Justice Asquith, he can't have meant them to be a point of principle. And it's just weighing up various factors and saying, was it reasonably practical or not? Those are the our submissions.
Thank you very much indeed. Ms. Foster?
Lord Manning.
Mr. Lim.
Lords, in 21st century terms, I'm just going to sort out my workstation. The wicket.
I should also point out we're not the occupiers of this building.
Yes. My lords, the wicket that was alluded to yesterday is now fairly trampled. So if at times I appear to be revisiting ground already travelled, I seek to do so only to make distinct points. And whether I score quick runs or not, my lords, I'll seek to do so as efficiently as possible, and that will involve, I hope, what appears to my lords only relatively sparing reference directly to the bundles. Section 29, the Factories Act. It might, my lords, at first be thought undesirable to adopt a restrictive interpretation of a provision concerned with health and safety at work. But my lords, as already noted, Section 29 was only a small part of complex statutory provisions concerned with health and safety at work. And my lords, our submission is that if the scheme and the context of the Act strongly suggests that a more restricted meaning is appropriate, it should not be rejected merely because health and safety are in issue. And we submit that general proposition is relevant both to the distinction I'll seek to develop between health and safety and relevant to whether noise is covered by the Act at all. My lord, so far as the distinction between health and safety is concerned, as explained to you yesterday, the Factories Act is in a variety of parts and distinguishes between health, Part 1, safety, Part 2, welfare, Part 3, and Part 4 allows for special provisions as to health, safety, and welfare. And we also know that Section 29 is, of course, in that part concerned with safety. And my lords, albeit not referring to Section 29 or its equivalent, I draw to your attention that Lord Justice Denning, as he then was, highlighted this distinction between parts as material, and he did so in the case of Clifford against Charles Challen. And also for the note, that's to be found in the Authorities Bundle, Volume 2, tab 25, at page 498, and we developed that submission in our printed case at paragraph 19. But he saw as material that the provision actually and misguidedly relied on by the claimant in that case was a welfare provision, not a safety provision. My Lords, I also draw to your attention that legislatively, before the woodworking regulations, noise was first referred to in a statute, and that was the Offices, Shops and Railway Premises Act of 1963. And again, for the note, that's to be found in the Authorities Bundle, Volume 10, tab 18. And within that Act, the 1963 Act, there is provision for special regulations to be made as to health, and the two prospective health problems that are referred to there are vibration and noise. My Lords, even in more recent times, my submission is that safety has not been taken as encompassing problems affecting health. The two have been referred to distinctly and continue to be referred to distinctly. And in that regard, it may be interesting to note the wording of Regulation 5.2 of the Construction, Health, Safety and Welfare Regulations 1996. For the note, that's in the Authorities Bundle, Volume 9, tab 5. And I simply read out, if I may, the actual wording of that regulation.
So regulation, did you say Regulation 5?
Regulation 5, Regulation 5.2.
2, thank you.
Every place of work, it provides, so far as is reasonably practicable, should be made and kept safe for, and then it adds, and without risks to health to, any person at work there. And my Lords, other factors that insidiously or cumulatively affect health over time have been addressed, we submit, in parts 1 and 4 of the Act. And again, we submit this confirms that Section 29 is not concerned with health. And within the printed case, that submission is to be found developed at paragraph 22. Now, I ventured that whatever its importance may now appear to be, Section 29 was only a small part of the complex statutory provisions. And in that regard, as a matter of record, the addition of the words place of work was, it might be thought, something of a legislator's afterthought. Because those words, place of work, were only introduced into the 1959 Act when the proposed clause to amend Section 26 of the 1936 Act to include place was only introduced at the 17th and last sitting of the Standing Committee. My Lords, again, for the reference, that's to be found in the annex to our case. And see in particular page 4 of that annex, which is in Core Bundle 1, page 309. The short point has already been made that if place did extend to environmental conditions, other provisions within the 1961 Act, such as Section 4 dealing with ventilation and Section 63, would be unnecessary. But, my Lords, it goes a little further than that, because reverting to Lord Care's example of yesterday, the room with the noxious gas, the remedy there is, of course, and has to be, Section 63. And it is instructive just to consider the words of Section 63, because for an employer to be liable under that section, it must be shown that there is given off dust or impurity of such a character, and quotes, and to such an extent as to be likely to be injurious or offensive to the persons employed there. In other words, it's likely to be injurious. Now, given that that is the position in relation to noise, it would be surprising, we submit, if an employer...
To dust.
To dust, forgive me. It would be surprising if an employer should be more difficultly placed as regards avoiding liability in respect of another environmental factor, that is noise, when noise is not even referred to within the Act at all. My Lord, that submission in our printed case is found at paragraph 85. The advance billing was that I would take...
Was section 63 in the earlier statute?
It was in the 1937 Act, section 47, my Lord. My Lords, the advance billing was that I would take you to the circumstances of the Factories Act enactment and post-parliamentary materials to make good the proposition that noise was not one of the mischiefs to which either the Act as a whole, which is, as it were, silent on noise, or Section 29 in particular was directed. As it happens, you've already been taken to the Wilson Committee by my learned friend Mr. Purchase, where, as he explained, it's recorded, we do not consider that the present knowledge of this complex problem provides a sufficient basis for legislation. There is the short but telling point, as reflected by annual factory inspectorate reports in 1965, that if the Factories Act applied to noise, no one told the Chief Inspector of Factories. And picking up, my Lords, on an inquiry of my Lord Clark as to the Lord Robbins report which led to the Health and Safety at Work Act, there is reference to noise, but as an environmental issue, and there's no suggestion that noise was covered by the Factories Act. Lords, if reference be required for that, it's in the Authorities Bundle 12, tab 17, pages 405, 406. It's sufficient for my purposes, I think, to go to the references that are summarised in the third appellant's case, specifically at paragraphs 4-7 and 4-8 in the annex to that case. That's to be found, of course, within Core Bundle Volume 1. I can invite my Lord's attention to that, and specifically pages 317 and 318 of that bundle.
Just give me the paragraph.
4-7 and 4-8, my Lord. And at 4-7, page 317 in Core Bundle 1, we find set out for the assistance of the Supreme Court the terms of reference and it's specifically recorded paragraph 3 at the top of page 13. The Factories Act 1961 contains no provision specifically dealing with noise, but under section 76 of the Act, the Secretary of State has the necessary powers to make regulations. And at 4-8, here is an extract from the publication recently referred to by my learned friend Mr. Purchase, that is Framing Noise Legislation, which my Lords will see was a report of the Industrial Health Advisory Subcommittee on Noise. And again, it's apparent from that that the understanding of the authors was that the Factories Act itself, and section 29 in particular, did not cover noise. The high point was that there was scope for making regulations by reference to...
What does it say then?
Sorry, what it says is there are no provisions specifically dealing with noise. Well, that's absolutely true.
Yes.
But do they address the question of whether Section 29 is wide enough to encompass it?
My Lord, not within framing noise legislation, but the understanding of the Minister in articulating the terms of reference was that the Factories Act doesn't contain any provisions dealing with noise, 4-7. And the understanding of the authors of framing noise legislation, again, was that Section 29 is not in point, there's no reference to it. All that is referred to in the context of the Factories Act is the provision for the making of regulations, which of course is Section 76. My Lords, so far as the exercise of the powers under Section 76, we know that they were exercised in at least one respect, because it was Section 76 that enabled the making of the 1974 woodworking regulations. And in passing, it's a remarkable feature of the respondent's case that there's actually no reference to those regulations at all. In all events, the 1974 regulations, my Lords, were made by the Secretary of State under powers given to him within the Act. And it's instructive to note that those regulations were referred to variously as being additional to or in substitution of the provisions of the Factories Act. They're to be found, my Lords, in the Authorities Bundle, Volume 10, Tab 23. And I simply draw to your Lordship's attention these features, that the regulations, for example, on temperature, Regulation 12, and guarding of machines, Regulation 16, were said to be in substitution of similar provisions under the Factories Act. By contrast, my Lords, under Part 10 of the regulations, where one finds Regulation 44, the regulation dealing with noise, it is not referred to as substituting anything within the Act itself.
We could hardly do that, could it? Since there was no reference to noise in the Act.
Well, if it was understood that noise was covered by Section 29, it could have said, so far as that is concerned, it is in substitution of Section 29 as it relates to the risk of noise. It does not.
There are obviously interesting questions if Section 29 applies to noise as to what would be the position in relation to people who are also subject to the regulations.
And my Lord, I'm going to develop submissions about that, because it seems to us that it's a recipe for incongruity and uncertainty, because there will be times where, if the Court of Appeal is right, those regulations coexist with Section 29 of the Factories Act. Well, perhaps we ought to go just briefly to the authority.
Under the Factories Act itself, do you say that, leaving noise out at the moment, do you say that there's no overlap between Section 29 and any other provision of the Factories Acts?
Yeah, my Lord, I do.
No overlap at all?
No overlap at all.
Sorry, well, I'm afraid I failed to make a note of the regulation which you say that does actually refer to the Factories Act.
My Lords, it's Regulation 12, temperature.
Thank you very much.
And Regulation 16, guarding of machines, where those regulations are spoken of as being in substitution
Yes, thank you.
of the Principal Act.
And there's power in it to make regulations in substitution for the Act.
Well, Lords, can I invite your attention as to those powers and also the procedures associated with them to Authorities Bundle 10.
Just before you do, you've given us the example of Regulation 12.
Yes.
Where does it tell us that that's in substitution for what was in the Act?
Well, I think that's to be found at the front of the regulations, where it explains which of them are in substitution of the Principal Act and those that are not.
Regulation 3.3.
Yes, thank you.
Also, I was going to invite your attention briefly, if I may, to one feature of the Factories Act that we've not yet considered. It's the fourth schedule to that Act. And that's to be found...
Sorry, just before you leave the substitution point.
Yes.
The substitution is made in relation to specific provisions in the Act, in the Principal Act, isn't that right?
Well, Lord, that's right.
Yes. Section 29 of its nature is of a general character, so it would be unusual, would it not, for there to be an expression of substitution of Section 29 if it applied to noise.
Well, my Lord, there was no suggestion in the text of the regulations or the guidance to the regulations that in some way Regulation 44, dealing with noise, overlapped with Section 29 of the Factories Act 1961.
Quite, but it couldn't ever substitute for it, could it?
Well, my Lord, insofar as Section 29 related to noise, to that extent and that extent only, it could. I don't think I can take that any further.
Just a matter of the general construction points, I don't myself see why, for example, comparing sections 28 and 29, you shouldn't have a factual circumstance which fell within both section 28 and section 29. There's nothing in the language of the statute to suggest that, is there? Section 29 doesn't say save as hereinbefore provided or anything like that.
No, Section 29 does not, and I can't read in words, of course, that are not there. But,
so that, for example, you could be in breach of both Section 28 and Section 29. If you, for example, fail to
Lord,
keep the stairs.
My primary submission is that Section 29 attaches itself to and is concerned with the place of work, its condition.
I quite understand that, but I quite understand you say noise isn't about place of work at all, and therefore noise is entirely outside Section 29. I quite follow that.
And also, may we go then to the fourth schedule of the 1961 Act. It's still within Authorities Bundle 10, and to be found within the bundle at page 434. Now, I draw this to your Lordship's attention because it's interesting to see the detail of the procedures that require to be followed before special regulations can be made. And these procedures were indeed followed before the 1974 regulations were passed. And what they entail is not simply notice of the proposal to make the regulations, but also the holding of an inquiry under that schedule into objections made to the draft regulations. And as a matter of record, my lords, that inquiry took place before the woodworking regulations were passed. And that inquiry is alluded to in the appendix to the framing noise legislation document. And what we say simply about that is that there you have the woodworking industry, which before it has visited on it specific regulations, has the advantage of draft regulations being published and an inquiry. By contrast, my lords, the decision of the Court of Appeal would retrospectively impose on the knitting industry, not an industry associated with excessive noise, standards more onerous than those for the woodworking industry without any such draft or any such inquiry. And I say that because, of course, the effect of the Court of Appeal's decision is to impose a standard or breach of duty for noise levels at 85 dB, whereas the scheme under the 1974 regulations, consistent with common law, consistent with the code of practice, was that it's 90 dB.
And do you make a point of the fact that, for example, the draft directive was issued as a draft in 1982, and there were a lot of objections to it by interested parties, and it was withdrawn. So different context, but the same subject matter, a subject on which interested parties have a lot to say.
Yeah.
And in relation to that draft directive, in the light of what was said, that was actually withdrawn.
Yes, my lord, I do make that point.
But of course, I mean, general provisions such as Section 3 and Section 4 of the Act presumably weren't the subject of inquiry before they were enacted, were they?
My lord, candidly, I don't know. All I can do is address you by reference to the 1974 regulations and the special provisions procedure. And whatever else, so far as they are concerned, they only came into being after the holding of an inquiry. And I contrast that, I've made the submission with the position of this industry.
Yes, but before the enactment of specific provisions in relation to temperature and ventilation, employers would have to comply with the general injunctions contained in Sections 3 and Section 4 without, presumably, the benefit of an inquiry.
Well, that's right. Can I now move to deal with...
So how does this latest point, I see it has a certain forensic attraction, but how does it fit into the argument?
It fits into the argument on the basis that what we have is in effect retrospective legislation by the Court of Appeal. In other words, they've imposed in the 1970s...
This isn't a question of construction then? This part of the argument assumes that noise is within Section 29.
Yes.
And then what? Then one simply has to decide whether we simply have to apply the section then, if it does apply.
Yes.
The fact there are no regulations is neither here nor there.
It's primarily an argument that noise is outside the scheme.
Yes,
Isn't it?
yes, I think that's really what you come back to, that because of this, what you would say is the anomalous position, then we should be driven to the conclusion that Section 29 doesn't cover noise.
My lord, yes, I'm seeking...
Although it's got nothing to do with the regulations, has it? Because if there were a similar provision to ventilation, with a general provision about ventilation, then there would be such a general provision.
My lord, there are really two strands of argument. First is the one of construction, whether the Factories Act applies to noise at all. And secondly is just to stand back and look at the situation, comparing what happened with the woodworking industry and the position of the knitting industry in the light of the Court of Appeal's
This is
judgment.
sort of jolly rotten for the knitting industry.
Yes.
The overall history appears to be that we have the Factories Act 959, which introduces the relevant phrase into whatever was the section then, becomes Section 29 of the 61 Act. I noticed that in the document we were referred to earlier this morning, Noise Final Report, the Committee on the Problem of Noise,
Yes.
that was actually set up in July 1960
Yes.
to examine the problem of noise. I think there was an overlap with, well, it's not entirely clear. There was a Mr. B.W. Robinson on the former, and Mr. D.W. Robinson produced the Hearing and Noise in Industry report. So maybe they're not the same person. They have rather similar names, but and they're both National Physical Laboratory. I wonder if there's a typographical error. It seems likely that he's the same man. So he was on the Committee on Noise. At the same time, he was working on the scientific work, which he produced in 62, is that right? It was published in 70, but the work was done, wasn't it, in the early 60s? Am I wrong?
It was, I think, in the early, and it's covered within the judgment, forgive me, my lord.
Yes. Well, whenever, it came out in 1970.
Yeah.
But about, no doubt, the fact that they had were about to receive the final report, noise final report, which they got in July 63, may well have had a lot to do with the insertion of Clause 21 dealing with noise and vibrations into the Offices, Shops and Railway Premises Act in mid-1963, in March 63.
Yeah.
It's difficult to think, and that's when it said this is a new subject on which we still have much to learn, no doubt anticipating that a few months later they'd get this report.
Right.
And so that I just wanted to check, that's really the context
It
in
is the
which
context.
we have to decide whether in 59, I suppose, noise was within the framework.
And then moving back
There we have to
forward-
decide whether place was in the framework.
Well, we have to decide the place as well.
Well, its place is the one is the addition to section 29. It would be difficult to decide the place point by specific reference to the noise position. Place point's a wider point. It stands or falls as a wider point. If the point taken by the appellant fails as a wider point, it would cover noise, surely.
I think that you take them as a separate point, don't you? I think the appellants and the respondents.
But instead it would have to be done as on the true construction of the meaning of place. You'd have to narrow place as meaning place, save as to noise, which would be, to my mind, part bizarre.
What aspects of place are covered is the question that arises, isn't it? Whether you're looking at the place as at a particular time and with reference to risks which could give rise to an accident, or whether you're looking at it as somewhere where people may work and over a long period prove susceptible, which I think you say is a health risk.
I do, my lord. Yeah. My lord, conscious of the time and
Well, I
conscious
follow
also...
that's a general health point rather than the noise.
Yes, anyway, let's go on.
My lord, can I venture on to the safe point? And in particular, the three propositions that we advance. First, safe does not mean 100% risk-free. Secondly, what is safe is determined by an objective as opposed to subjective standard, and in particular the prevailing standards of the day, and not retrospectively by a later standard. And thirdly, that what is safe should involve a consideration of reasonably foreseeable risks. And I'll just speak to each of those, if I may, in turn. As to the first proposition, safe does not mean 100% risk-free. Our submission is that neither the courts nor indeed the legislature have said that it is wrong for employers to run risk. It may be acceptable, both at common law and under statute. In short, risk is relative. It involves a qualitative assessment. It is not absolute. My lords, in our case, our printed case at paragraph 70, we draw your lordship's attention to two dicta from the House of Lords case of Bristol magistrates and the speeches of Lord Hobhouse and Lord Nichols. Lord Hobhouse at paragraph 103, Lord Nichols at paragraph 22. And as there said by Lord Hobhouse, safety is a question of opinion. There is no such thing as absolute safety. All safety is relative. Two men can legitimately hold different opinions whether a machine is safe or unsafe. So safe, we submit, is a question of fact and degree. Such a construction is consistent with how the word safe was being interpreted both before and after the enactment of the 1961 Act. As to cases before, we draw your lordship's attention to Sheppey and Trott, and as to cases after, Paramore, already referred to, and Byrne. And they're dealt with at paragraph 73 to 75 of our case. And we rely on them not only for the recognition that safe cannot be construed as meaning absolutely safe, but also with the rule in pari materia in mind in terms of statutory interpretation. That is, it is to be assumed that legislators intended a word to be interpreted in the way it had previously been. Lords, can I just illustrate these points by reference to a case of occupational injury involving not noise but vibration, and as it happens, a case relied on by the respondent, and that is the case of Doherty. For my Lord's notes, it's referred to in the respondent's case at paragraphs 15 and 186, and is to be found in the Authorities Bundle, Volume 3, at tab 38. Tab 38. Thank you. Now, as with deafness, and the standard of 90 dBA, so also put shortly with vibration, there was a damage risk criterion. That phrase, damage risk criterion, is not an advocate's one. It's found within the health and safety literature and found also in Judge Ingall's judgment at paragraph 48. And my lords, in the context of vibration, the damage risk criterion was set again by a British standard at 2.8 metres per second squared. That's the unit of measurement for vibration. And the summary position is that exposure at that level over a 10-year period would expose 10% of the working population to having vascular symptoms. So there was an appreciation that for exposure at that level or above, 10% of the population would get vascular problems. Now, the Court of Appeal concluded in Doherty that it was acceptable for employers to expose employees up to that level, provided always, to cater for the susceptible, warning and monitoring was given. And all the Court of Appeal in effect said is that following the discovery of the symptoms, it would be negligent for the employer to cause the employee to continue working with the vibratory tools. Well, that's found within the judgment of Mr. Justice Wilson, as I think he then was at paragraph 42 in Doherty. So the fact of having symptoms alone does not render the employer liable. So the submission is that in vibration injury, there was and is a general standard or limit of exposure, which does not eliminate all risk, but to which employees are allowed to be exposed by their employees. As that was appropriate in vibration, so also in deafness. And that is, my lords, most appositely demonstrated by the Noise at Work Regulations 1989. And can I invite my lords' attention back to the Authorities Bundle, Volume 10, but now at tab 16. And specifically, my lords, if you would go please to Regulation 8 of the 1989 regulations.
Doherty was a common law claim.
My lord, it was.
Yes, so the test is overtly whether the employer had taken reasonable and prudent steps to look after the safety.
Yes.
So it may not be reliable as a definition of what safe is. It's reliable as a definition of what reasonable steps to keep employees safe.
But, my lord, it reflects an acceptance by the courts that absolute safety is not necessarily looked for, and there are circumstances, including occupational injury cases, specifically occupational injury cases, where it may be acceptable to expose to a risk of injury. Well, can I invite your attention to Regulation 8 and specifically Regulation 8.2. The scheme of the 1989 regulations is that it proposed a first action level, 85 dBA, and then a second action level, 90 dBA. And all that was required under Regulation 8.2 is that every employer shall ensure, so far as is practicable, that when any of his employees is to be exposed to the second action level or above, or to the peak action level or above, that employee is provided with suitable personal ear protectors, which, when properly worn, can reasonably be expected to keep the risk of damage to that employee's hearing to below that arising from the second action level. So it suffices that the hearing protection gets you below the second action level. It doesn't have to get you below the first action level. So the legislature envisaged, specifically in the context of noise, that you didn't have to eliminate all risk, you just had to provide hearing protection that got you below the second action level.
And what's the first action level?
85 dBA, my lord.
And where do we see that? That's in the regulation.
That's within the regulation.
Regulation 2.
Yeah.
My Lords, the second proposition that I advanced was in regard to safety, that one's looking at objective standard and the prevailing standards of the day, and that's found within our printed case.
Under 8.1, is there
Yes.
any obligation to offer the employee such protection?
The requirement is that if the noise levels are above 85, you inform and warn, and if the employee asks for hearing protection, then you provide the employee with hearing protection.
And where's the obligation to warn?
My Lords, that is...
Regulation 4.
My Lords, I think it actually comes later. It's Regulation 11. And you'll see how Regulation 11, subparagraph C, then refers back to Regulation 8.1.
So that if the between 85 and 90, the obligation is to warn or give information,
Yes, my Lord.
and then it's up to the employee to decide whether or not to
In the light
wear
of
the
that,
ear protectors, and there's no obligation to take the steps in 8.2.
yes. Well, the second proposition that I heralded was going to be advanced is that one's concerned in looking at safety with objective standards and the prevailing standards of the day. In the printed case, that's at paragraph 77 to 79. The effects we submit of long-term exposure to environmental conditions affecting health are quintessentially an area where legislators and industry rely on the work of experts. You don't need to be an expert to know that a slippery substance on a factory floor is a bad thing. But where you're talking about environmental conditions, experts are key. And in deafness, it was the experts who produced the seminal code of practice. The code of practice constituted a bespoke risk assessment. It could not have been better. The status and utility of that code really ought to be beyond argument. In the law-making context, the 1974 regulations were referred to and understood by the Chief Inspector of Factories as giving legal backing to the code. Well, that's paragraph 8, in fact, of Courtauld's case. And it was the code which not simply prompted, but enabled the publication of framing noise legislation. Now, so far as the code is concerned, again, it wasn't looking for absolute safety. It recognised 90 dBA as a maximum acceptable level, and I stress the word acceptable. The code of practice did not set the standards so as to guarantee the removal of all risk of hearing loss, which risk remained even if the standard was adhered to, on account of the large inherent variations of susceptibility between individuals. And those words are specifically used in the code of practice. Lord, it's to be found at paragraph 112 of the Code of Practice, which of course is in Core Bundle Volume 3, Tab 13. So the code took account of the susceptible as well as the non-susceptible. And our submission is that in setting such a standard, the Code of Practice was authoritatively and helpfully providing the paradigm for what level of noise ought to be regarded as sufficiently safe. It avoided a situation where the deemed appropriate standard was not subject to a particular individual's assessment of risk. And on the evidence in our case, we know that if asked at the time, engineers would have concluded that the steps to be taken were those required to comply with the standards in the code. Well, that's the judgment of paragraphs 46 to 48. And I just invite your lordships to consider what would be the position if the standard of safety is not based on the code, as was the 1974 regulations. Our submission is that problems of different standards and then incongruity become readily apparent if the threshold for liability under section 29 is set at 85 dB, as does the Court of Appeal. It would produce these results. It would lead to inconsistency in tension with the woodworking regulations. That ground is already covered, but there's more within our printed case at paragraphs 52 to 56. But let it be noted that the woodworking regulations coexisted for 16 years, that is from 1974 to 1990, with the Factories Act. So what if the appellants...
Well, it would bring the regulations we've been just looking at in de facto into operation earlier, wouldn't it?
Well, my Lord, I think
Never mind the woodworking regulations.
The concern I'm seeking to address or invite your lordships to consider is what if the appellants were not in the knitting industry, but the woodworking industry? On the evidence in this case, they complied with Regulation 44 of the woodworking regulations. They may have thought, well, we've done what was required of us by the applicable statutory framework at the time. And yet, 30 years later, the Court of Appeal says, no, you're in breach of statutory duty under Section 29. That is an incongruent and unfair result. It's wrong, we say, if Section 29 is a general provision, for it to override a specific...
So the regulations we've just been looking at, do they exclude the woodworking industry?
The noise
The
at work
1981,
regulations,
yes.
1989, they're of general application across industry.
So they apply to woodworking as well?
So they apply to woodworking as well. And that's why I said...
And they therefore contain some provisions, namely the one we looked at,
Yes,
which are more severe from the employer's point of view.
than were
Than the
those at
woodworking.
1974. But the 1989 regulations and the requirements they impose are, we submit, actually less severe in terms of what is required of an employer than the Court of Appeal's judgment would allow.
They repealed. 89 regs repealed the 74.
Yes.
Sorry, say that again.
Well, I'm just reminded, I think it was apparent from my submission in all events, that the 1989 regulations repealed the 1974 regulation. The Lord has that. But what I'm saying is that the requirements of the 1989 regulations were in fact lower than would be imposed on the employer if the Court of Appeal is right.
In what respect?
The Court of
About
Appeal
Section
would make it compulsory on employer occupiers to require employees to wear earmuffs,
Yes.
protective hearing devices above 85,
Yes.
and
And the Court
whereas the regulations don't.
And the Court of Appeal would also say that you need to have absolute safety, whereas the regulations say, well, all you need to do is get it down below the second action level. There it is.
I suppose someone in the woodworking industry would be able to say, I'm subject to these special regulations, which, although on the face of it they were introduced as the only legislative scheme, are in fact, if it proves not the only one, they are less stringent than the general.
Yes, but it would be ironic that an industry that was singled out as bad for noise, hence the need for the regulations, is in fact in a better position than all other industries, because of course woodworking machines will be used in a factory context.
The 1989 regulations, in fact, repealed the noise provisions of the 1974.
That's correct, my Lord.
Yes.
Exactly so. And I mean, just to complete this submission about the regulations and the point at which the regulations catch up with the way in which the Court of Appeal interpreted Section 29, it's not until the Control of Noise at Work Regulations 2005 that what the Court of Appeal said should have been done by an employer so as to avoid liability under Section 29 was in fact enacted by regulations. And the Control of Noise at Work regulations are to be found in the Authorities Bundle, Volume 9, Tab 6, pages 87 to 98. I don't invite you to go to them at this stage, my lords. But what I say, drawing those threads together, it's within paragraph 79 of our printed case, is that it is or ought to be a principle of legal policy that changes in the law should not take effect retrospectively. Law must be predictable, certain and just. And if safe under section 29 is considered retrospectively and with the benefit of hindsight, that amounts to moving the goalposts and results not only in law which is uncertain and unpredictable, but which is obviously unfair. In other words, a modern statement of the need for certainty and predictability is to be found within the speech of Lord Diplock in the Black Clawson case, and that's, as I say, paragraph 79 of our printed case, and to be found in the Authorities Bundle, volume 2, tab 15, at page 392.
What was that about?
Lord, an altogether different matter. It wasn't employers' liability.
I think we can take the general proposition that
But it contains a general proposition.
retrospective legislation, if one's talking about that, is not something to be encouraged, lightly accepted, and certainty is important.
Yeah. And I simply ask, with all of that in mind rhetorically, how can anyone know in advance the legal consequences if there is to be a retrospective assessment of what is safe? Since the section, which is in a penal act, requires you to make the place safe, how can you make something safe which is on current knowledge already safe? That is the fallacy in the Court of Appeal's judgment. And that is why I also submit it does matter to import reasonable foreseeability into an assessment of safe. Because if new knowledge or standards are applied back to historic exposures, it is not enough, it is not fair to say that there is still the defence of reasonable practicability. Because quite simply, as time moves on, it becomes more and more difficult to prove one's case on reasonable practicability. Well, it's the third proposition, safe and reasonable foreseeability. Some short points. The mere fact that the word...
So I don't follow that last point. If you can prove your case on safety, in other words, or disprove a case against you, why is it any less easy to prove a case on reasonable practicability if they cover the same ground? And I appreciate that to be...
Well, there's been some debate both at the bar and amongst your lordships about whether we look at reasonable foreseeability both at the stage of safe and reasonable practicability, or whether there's a hard view taken of what is safe.
I appreciate that. My question was a slightly different one. You suggested that it was more difficult to satisfy it if it only came in at the later stage of reasonable practicability. Why?
Why? Because if you're told 40 years later that what you thought was doing was safe was in fact unsafe, you're then several decades on, scrabbling around, looking for evidence, trying to make good a plea of reasonable practicability.
Well, surely you say we had no means of knowing 40 years ago that there was anything to guard against. Therefore, it cannot be reasonably practicable for us to introduce measures.
Well, that would be part of the answer, but another part of the answer would be, if you had it, to muster evidence in support of your plea of reasonable practicability.
But you're going to have the same evidence mustered in support of an argument about safety. So it's just a question of onus, isn't it?
My Lord, it certainly is a question of onus.
I mean, I think there is a big question, of course, as to whether, if it doesn't come in under safety, then reasonable practicability allows it all to come in. We haven't heard much by way of submissions from the appellants yet on that, but it may be you're going to cover it. It struck me that Marshall and Gotham was an interesting case, but there may be others.
Look, Lord, I will cover it very briefly without specific reference to authority. Can I canter through, conscious as I am of the time?
Yes, I hope you've agreed with Mr. Kent sufficient time, have you?
Yes. Safe and reasonable foreseeability, a few short points. The mere fact that the words reasonable foreseeability are not used, we submit as neither here nor there. And in support of that, we draw your Lordship's attention to a recent case of Horton against Taplin. It's referred to at paragraph 87 in our printed case, and the specific approval of that case by the House of Lords in Robb and Salamis. My Lords, we submit that in deciding on whether reasonable foreseeability is an element in considering if a place of work is safe, it is appropriate to have regard to the construction given to other provisions, specifically section 14, where the word dangerous is used. And it is appropriate to do that because dangerous has been understood as an antonym of the word safe. And there, of course, we repeat the reliance placed on the observations of Lord Reid in John Summers. I simply draw your Lordship's attention to the fact that that case, and specifically those observations, were all considered and approved by 5 of their Lordships in the case of Close, which is found in the Authorities Bundle, Volume 2, Tab 26, which authority, unhappily, was not cited to the Court of Appeal in Lana. Lords, engaging momentarily with the respondents' submissions on this aspect, what they seek to do, as you will see...
Can you just give us the references to the Horton and
Forgive me, my
Robb?
Lord. Yes, the Horton case is Volume 3, Tab 56, and Robb and Salamis is Volume 6, Tab 100.
Okay.
So you say that in Close, that what the decision of the House of Lords, that what Lord Reid said about the meaning of safety or dangerousness was endorsed.
Yes, I do know.
Well, was it? I must say I haven't looked at that. That's referred to in your paragraph 86.
This is my Lord. There's a few short submissions, if I may, on the respondent's approach to this aspect. That is, looking at authority and seeing what relevance is given to reasonable foreseeability with other provisions under the Factories Act. There is an obvious tension, we say, between the respondents arguing on the one hand, ignore the authorities on section 14, and in particular John Summers, where regard is had to reasonable foreseeability, but rely on other provisions, such as the construction of section 28, and they rely on the cases of Bennett and Gillies, and this is paragraphs 89 and 96 in their case.
In their case?
Yes.
Yes.
And they rely in that regard specifically on the observations of Lord Sutherland in Mains, the Scottish case, where he cautions against construing the word safe in section 29 by reference to authorities dealing with dangerous in section 14. Well, all we say is that if that objection applies to sections within the same part of an act, because sections 14 and 29 are both within the safety part of the act, then the same objection would be all the more compelling when comparisons are sought to be made between section 29 and cases concerning COSH and the provision and use of work equipment regulations. And that, we say, disposes of paragraphs 102 to 106 of the respondent's case. And in the same vein, at paragraph 106, they rely specifically on Ball and Street. And that was a case where the Court of Appeal determined that whatever the House of Lords had said in the case of Feitch about personal protective equipment regulations and Regulation 7 couldn't assist with the construction of Regulation 5 of the provision and use of work equipment regulations. So we say, that being so, how can decisions under the six-pack regulations be taken as of assistance in the interpretation of safe in section 29? Also, the concluding submission so far as safe and moving very briefly onto reasonable practicability is concerned, is this. We need to have in mind the question of time. Because whatever else, it's agreed between the parties that when assessing reasonable practicability, one looks at matters before the event. And our submission is a simple one. It's logically incoherent to determine reasonable practicability before the event, but safety after it.
Sorry, what event?
Well, the event, that is the occurrence of the injury or the exposure. In other words, the event in the context of these cases is exposing employees to noise. And it's accepted between the parties that so far as reasonable practicability is concerned, you look at that before the event. But there's a logical incoherence in then saying, but you look at safety after it. A determination of whether the place is safe, and if not, whether it was safe within the limits of reasonable practicability, should be made at the same time.
Well, why? Why is it necessary to have a coincident examination of two quite different concepts?
Well, there's no logic to it, my lord.
I think you're saying there is a logic to it, and my Lord's question is why the one may
No,
cater...
I'm saying there's no logic to looking at matters disjunctively in that way, that you would look at reasonable practicability before the event, but safety after it.
Well, it may be that the concept of safety is an eternal, but the modification or the mitigation, as far as the occupier is concerned, is that you look at the state of mind at the time.
Oh, yes.
This is back to the reasonable foreseeability point. I mean,
Oh,
obviously,
it
if you're
is.
going to, if reasonable foreseeability is a relevant test, then presumably you do have to look at it at the earlier stage.
It's back to that.
But if there's an absolute, if safety is a more absolute concept, as in the smoking example, for example.
Well, Lord, it's back to that, and it's back also to putting it in the context that we're not dealing here with a one-off incident, as it were, conventional accident at work as in Lana. We're dealing with occupational exposure, something that will happen over time. Well, can I make one submission so far as reasonable practicability is concerned, and do so by reference to the Code of Practice? Can we go, please, to Core Bundle 3? And specifically, page 1069. Code of Practice is found, of course, after tab 13.
Sorry, what page, please?
My lord, it's page 1069 within the bundle. This is, of course, the document you were taken to and through by my learned friend, Mr. Nolan. But there's one passage that I think bears reading and that wasn't read out. It's at section 3.1.2. And it says there that the aim should be the general reduction of noise exposure. Where noise exposure less than the limits set in section 4 are not achieved, ear protectors should be provided and their use ensured. And of course, section 4 identifies the limit as being not to exceed 90 dBA. Now, what I say about that is that any employer reading that code would understand that if noise was below that level, the code does not require the provision of hearing protection. And that from first to last in reviewing the documents in this case, one sees a clear distinction drawn between, on the one hand, reduction of noise exposure, and on the other hand, the provision of suitable and effective ear protectors to employees exposed at or over 90 dBA. That distinction runs through the noise and the worker, the Code of Practice, the HSE consultative documents, and is even given clear statutory recognition by the 1989 regulations. Well, so far as the noise in the worker is concerned, the reference there is Core Bundle Volume 3, Tab 9 at page 912, where it said, where it is not possible by environmental control to reduce noise to sufficiently safe levels, workers should be protected by ear defenders. And, my Lords, if we can look again at framing noise legislation.
Just remind me what date is, it's 63, isn't it?
63. The final report, I think, was July 1963. If we move forwards to 1975, my Lords.
This refers, it's interesting, it refers to the report of the committee, the Wilson Committee of March 63.
So I think there was a report, or indeed reports, before the final report.
Yes, I see. So that, I mean, that fits extremely closely with the March 63 parliamentary references to the introduction to the legislation for the first time of noise regulation.
Yes.
Yes.
So this distinction between noise exposure on the one hand and ear protectors on the other is to be found also in framing noise legislation. Lords, that's to be found in the third appellant's supplementary bundle at tab 3, and also in the appendix part 3, volume 4, tab 31. And I simply invite your attention, my Lords, to paragraph 12 within framing noise legislation. And if the Lords can turn that up, you'll see within paragraph 12 this passage. The noise exposure limits given in the code are not meant to be limits of exposure which ought never to be exceeded in any circumstances. They represent not to exceed limits of noise exposure only where ear protection is not worn, and are also intended as levels above which certain action is to be taken. The code recommends that this action must include measures to reduce or control noise exposure, and where the measures fail to reduce the noise exposure to below the limits or action levels, provision of ear protection. The latter is quite distinct from and is not considered as a measure to reduce or control noise exposure. As I say, that distinction is continued and drawn in the 1989 regulations when one compares regulations 6 and 8. And quite simply, my Lords, there is logic to that approach once it is recognised or appreciated that the danger was identified at or over 90 dBA. The duty to provide suitable and effective ear protectors below the recommended level was not triggered, according to the best practices then in place and in place throughout the material time. My Lords, so far as the printed case is concerned on reasonable practicability, it's to be found chiefly at paragraphs 89 to 101, and again at 108 to 117. And I stress there the importance of the whole circumstances, but it's not a test necessarily of gross disproportion. Well, so far as common law is concerned, I deal with that in but a few sentences. My Lord Mance was interested in the factual position, of course, so far as courtolds is concerned. So far as Pretty Polly is concerned, my Lord, that is helpfully summarised by the Court of Appeal at paragraph 39. And it says there that there was nothing to suggest that Pretty Polly had received a direct recommendation from its legal or medical departments, such as courtolds had received, and nothing to suggest that it had taken part in the debate on the 1982 draft directive. There was evidence that in 1975 a factory inspector had found noise levels of 85 dBA, but had not recommended that any steps be taken. In a sense, the question falls as to whether Pretty Polly is a greater than average knowledge employer, because it's not a finding that the respondent is pressing for. What is expressly and helpfully recognised by the respondent's case, that when we're talking about knowledge in cases of this sort, it's really done by reference to the documents. And Pretty Polly had no more, no less documents than anyone else. So we say, in short, that the mistake made by the Court of Appeal in relation to Quantum, describing it as an employer with greater than average knowledge, was the mistake made by the judge at first instance. That is, to found inferences on documents that were simply in the public domain. That was the sole basis for finding that Pretty Polly was an employer with greater than average knowledge. So it's a finding of fact that was not indicated on the evidence, not sought by the respondent, and finally not justified as a matter of law. Because as a matter of law, as Lord Justice Neuberger, as he then was, explained in Harris, there ought to be, for good reason, a generally applicable standard. And the truth of that applies not only to common law, but also to statute. Well, unless I can assist further, those are my submissions.
Thank you very much indeed. Mr. Stewart? Yes. Mr. Kent.
The party I represent, Guy Warwick, applied to intervene in this appeal for two reasons. One, that it's not academic from their point of view. They face an attempt to rewrite the costs order in our favour below in the light of the Court of Appeal's judgment, on the basis that some issues should have been decided against us, even though ultimately we won the case. Secondly, my clients, Guy Warwick, are following the decision of the Court of Appeal, the only defendant amongst those before Judge Ingalls in the test litigation, who are held not to have had special knowledge. I therefore stand as the representative of the average or smaller employer. Indeed, Guy Warwick were unembarrassed by having even any general knowledge. It was a finding of the learned judge that we didn't even know about the code of practice or indeed the noise at work regulations when they came into force. Because it was test litigation, in the context of managed cases amounting to some 700 issued claims in Nottingham, the learned judge, in a series of case management decisions, selected suitable cases, and it was explicitly to assist in providing some guidance at all levels of size of employer that Guy Warwick were included in that. We're not that small. We had 400 employees, but it seemed difficult to find a suitable smaller employer. The reason I mention that, Lords, is that the Factories Act, one can see from section 175, applies, and the section we're looking at applies, to a place which is where a manual labour is carried out on certain processes with no lower limit of size. There can be one person carrying out those processes by way of manual labour, and therefore it applies as much to the smallest workshop as to the largest conglomerate like Courtaulds and their factories with tens of thousands, or their operations with tens of thousands of employees. And Lords, we note that in the respondent's case, in Core Bundle 1, tab 8, right at the end, there is what appears to be a welcome comment, welcome from the point of view of the smaller employer, made by the respondents. Paragraph 218 says this: it is accepted that in another case, the lack of resources of a small employer might affect constructive knowledge and hence reasonable practicability under Section 29 and reasonable measures in negligence. It may seem churlish not to quarrel with that, but we respectfully suggest that that is not an offer that can be accepted by us as spokesmen for the small employer. Interestingly, in the proceedings in the Court of Appeal, Lord Justice Sedley, we by chance have the transcript, in Core Bundle Volume 2 at tab 8, and because of the pagination is rather strange, looking right at the foot, it's page 643 of the Core Bundle. Lord Justice Sedley and my own friend Mr. Hendy debated this question of different gradations of constructive knowledge. And in the, just above the middle of the page, Lord Justice Sedley says that breaks down, again, anybody who actually knows more than they are legally required to know is fixed with that the extra they know. That's common sense. But do you say that larger companies are constructively taken to know more than smaller companies because of their resources? Mr. Handy, we do say that as well, subject to a minimum standard across all industry. And then dropping down to the last comment by Lord Justice Sedley, this produces an almost unworkable taxonomy of knowledge for insurers, for advisors, for judges. It's not the most attractive paradigm, one in which the standard to be expected of all employers, a constant and possibly in your submission a rigorous one in relation to safety. They are deemed to know big or small, they are deemed to know what an employer should know if you do not have the resources. And Lord Justice Sedley's difficulties with respect to my own friend Mr. Hendy must be right, because otherwise we are faced with the prospect of an inquiry in any given case, not only as to the actual knowledge of that employer, but as to the relevant level of constructive knowledge that might be attributed to him. And the reason I'm making these submissions is because, having indicated that the Factories Act will apply to the smallest operation, perhaps only one person at manual labour in it, it is a necessary background to a consideration as to what Parliament must have intended in enacting a provision requiring a place of work to be safe, and what standards it was seeking to impose when those standards, we say, must be uniform across the whole of industry where factories are in operation. And we say that the standard that has been set by the Court of Appeal is therefore unworkably high, because one has to bear in mind what it is that the smaller employer is expected to meet. We say, and this seems to be common ground, that the question of what is safe is an objective question. And so there's no suggestion that that can vary according to the size and resources of the employer. That being the case, we do have points to make, and they've been made by others already in this appeal, to the effect that the Court of Appeal have in fact imposed a standard that was quite unmeetable. The Factories Act itself has been pored over sufficiently for me to avoid saying anything much more about it. May I just mention one feature which my Lord Mance noted, which was Section 6 refers to drainage. My Lord wondered whether that could be said, although it's under the Part 1, the health provisions, also to be directed at safety, because people can slip on wet floors. In fact, Section 28 under the Part 2 explicitly refers to substances likely to cause persons to slip. So the workman is protected in any event by Section 28 from that problem.
So Section 6 is the sort of general health hazards of having wet floors where you get wet shoes and that sort of thing.
Or possibly infection or and that sort of thing. The word safe, I add little to the debate, save to say this: it does seem that my learned friends, for the respondents, seek to sidestep the Summers and Frost line of authority, or one way they seek to sidestep it is to say, well, that the courts were having to consider in Section 14 an obligation which did not provide the employer with this this let out of reasonable practicability, this qualitative test, and therefore were driven to avoid what might have been regarded as an absurd situation where there was no such protection. The problem is that the word, one needs to remember that the word safe, that very word appears in Section 14 as well as in Section 29. It's not just that it's the antonym of dangerous. Section 14.1 in the second limb requires the part to be, or maybe fenced in such a way as to be as safe as if it were securely fenced. It uses that very word safe. And that's all I say about that. The only additional point to make is to respond to my Lord Clerk's request as to what the jury might be directed in a prosecution as to the first limb, was this place of work safe? One answer may be to say these are words, ordinary words of the English language, and it wouldn't be appropriate to seek to direct the jury at all, but that's perhaps not a satisfactory answer. If the jury needed guidance, then we would say that the judge would say to the jury, well, you've heard evidence from the defence in this case, including an expert engineer who says he's never come across this problem before, for example, or it's a very rare problem. And it's a matter for you as representing the reasonable person to decide in the light of that, as well as in the light of the fact that it's been proved there was an accident or an injury, whether this place of work was unsafe. What would not be acceptable is some sort of compartmentalising it, whereby the jury were told, ignore all the evidence you've heard about knowledge of risk and the standard, for example, if there was evidence of a code of practice, and consider safe in isolation, and then bring back into your mind that evidence when you consider whether the defence of reasonable practicability. We simply say there will be no no-go areas for the jury, because it's a question of fact and degree, to use a trite phrase, in which the fact-finding tribunal is simply seeking to answer the question posed by the section, which is using perfectly ordinary words of the English language. And what we then will seek to do in the moments I have is to try and look at the implications of the Court of Appeal decision. One way of doing that, if your lordships still have my learned friend Mr. Hendy's printed case to hand, he gives, for other purposes, he cites a case called Green and Building Scene at paragraph 156. Of the case, and this was to make was to identify a case where a code of practice and indeed some regulations were not on the face of it complied with. So rather the opposite problem that we have here. A visitor to a shop injures herself falling down a short flight of stairs, and she proved that there were building regulations in force that required a handrail to be put in the middle of the flight because it was a wide flight. And she also recited a code of practice issued by the British Standards Institute. The trial judge and the Court of Appeal agreed, said, well, that's nothing to the point. The finding of fact was that this was not unsafe. And that's recited by Lord Justice Ralph Gibson. No ordinary bystander or any informed person looking at this stairway would ever say it requires a central handrail, and therefore it was not unsafe. And incidentally, a similar conclusion was reached in the case, a point was made in the case of Ward and the Ritz Hotel. But if one imagines that it changes the facts slightly, if that had been a factory and the plaintiff had been a person employed in that factory, whether an employee of the defendant or not, then logically applying the reasoning of the Court of Appeal in this case, it would be said that there was a breach of Section 29, means of access probably rather than place of work, because the existence of the building regulations inferentially tells you that there's a greater risk of injury on stairs not having a handrail of that width, not having a central handrail. And so does the British Standard Code of Practice. So you have knowledge of a risk. You don't know if anyone's going to succumb to it. It's not a fanciful risk. Whoever drew up the regulations would hardly have required such provision unless there was some reason to do so. The injury has now happened, and let us assume that putting a handrail in would not have been difficult because the premises had recently been altered and it was perfectly feasible to do so. Then the claimant succeeds, notwithstanding the finding that this is not, standing back and looking at it, an unsafe place of work or an unsafe means of access, answering that question as a jury question. And that's the sort of practical problem we say that the Court of Appeal's decision gives rise to. It needs to be, going back to the question of noise, it must not be forgotten that the Code of Practice, which would have been until, certainly until the Health and Safety at Work Act came in, so there was a period of a couple of years or so after the Code of Practice was promulgated, would have been the basis for any prosecution by the factory inspectorate for exposure to excessive noise. And nevertheless, one has the Code of Practice telling one in Section 8, which deals with job rotation and other measures to keep the equivalent daily noise exposure to below 90 dBA, there's an explicit acknowledgement that employees may be exposed to higher than 90 dBA without any hearing protection, as long as such measures are in place to ensure that they don't reach the equivalent 8-hour dose. And it's all about the overall dose. And that proposition is put forward, or that observation is made, again, by way of illustrating the difficulties which the Court of Appeal's approach gives rise to, which is that not only, as has been said by my learned friends, in particular my learned friend Mr. Lim just now, that the Court of Appeal are requiring a standard that didn't, as far as regulation is concerned, come into force until the 2005 regulations. But that is to say, enforcement of hearing protection between 85 and 90 dBA. But was against a background that the Code of Practice, and indeed the woodworking machine regulations, 1974, Regulation 44, and indeed the noise at work regulations, 1989, accepted that as long as you have proper job rotation and so on, you can expose without hearing protection people above 90 dBA. And of course, the problem that also illustrates is this difficulty of saying that this could ever be a breach of Section 29 itself, because you could never say, looking at it by way of a snapshot on any one day, that an employer or an occupier of a factory was in breach merely because there is someone who is exposed to above 90, let alone above 85 dBA. You have to know more, you have to factor in the component of time and to arrive at the equivalent noise level. And I can also illustrate the problem when I come in a little later to what the Court of Appeal say should have happened, which gives rise to the date when, for the average employer, query whether that includes the smallest employer, but logically it seems to, should have been in possession of enough information for that employer reasonably, practicably to do something about it. But before I do that, can I just take the court to the way in which Lady Justice Smith introduced, first of all, the reasonable practicability test and discussed it in Core Bundle 2, tab 3. At paragraph 89. And this is the paragraph in which Her Ladyship explains why the result under Section 29 is different from the result at common law. And it's not because of the burden of proof. Nothing turned on the burden of proof in these cases. The judge made his findings of fact on all the evidence. And what she says is that if one drops down to 5 lines down, under the statute, the employer must first consider whether the employee's place of work is safe. That's a curious part of the judgment, because in other parts it appears to be stated that what the employer considers, whether as an objective matter or a subjective matter, is neither here nor there. But that's the first thing. If the place of work is not safe, even though the danger is not of grave injury, or the risk is very likely to, occur, duty is to do what is reasonably practical to eliminate it. And then she has the reference to the quantum of risk and the substantially outweighing. That's a reference back to Edwards, the National Coal Board, that seeing the test as being one of gross disproportion. And then at the end, I cannot see why the fact that a responsible or official body has suggested that a particular level of risk is acceptable should be relevant to what is reasonably practicable. So, to be clear, the Code of Practice is not only not determinative, it's not even relevant, according to the Court of Appeal.
She says in the middle, once any risk has been identified.
Yes, well, that's right.
But I mean, logically, her approach must mean even if it hasn't been identified.
I put against it, including with hindsight, because otherwise it's...
Yes. Well, I think that's what must have been intended, because otherwise other parts of the judgment wouldn't dovetail with this. And I'm not here construing the statute and therefore trying to attach strained meanings to words. But the point is, it is clearly here stated that the official guidance isn't even relevant on the reasonable practicability test, let alone conclusive. And we see how...
It's curious, because I thought earlier she'd said that it was conceded on behalf of the claimant, that a wider notion of reasonable foreseeability was relevant at the second stage. Did she not say that earlier?
Well, she says at 83, a matter of common sense, if the employer does not know of the risk, it cannot reasonably be expected to know, it cannot be reasonably practicable to take steps.
Yes.
And she says that again at 91.
So that is the way in which the Court of Appeal prevented this decision, as it were, running completely out of control and taking liability right back to 1960.
But once you say, as she does in paragraph 91, it's difficult to see what's meant by the bit in the middle of 89.
Well, can I then, perhaps it's explained in paragraph 101, where Lady Justice Smith then tells us or identifies how the quantum of risk is to be assessed. And this is all to be applied to the smallest employer. This is she speaks of the average. There she says, I do not suggest that the content of the Code of Practice was irrelevant to the employer's assessment of the quantum of risk. However, it was itself plainly inadequate as an assessment tool. Advised there was some risk to susceptible individuals below 90. We quibble whether it really says that, but that's a matter of impression as to what the Code says. It certainly doesn't say it was likely that there was danger, as is said earlier in this judgment at paragraph 6. But dropping down to a third of the way down this paragraph, she says expert evidence was required for a proper assessment. The question to be asked of the expert would have been, how many of my workers in this workshop are likely to be affected by the noise, and how severely? Except until the publication of the British Standard, it was not easy to assess the quantum of risk from noise in the 85 to 90 dBA range. But she then says an ordinary acoustic engineer would be able to do that. And so sets the date at which that process is set in train as early 1977. And what we then have to do, the small employer or his acoustic engineer, who one assumes is not going to have the qualifications of the membership of the subcommittee of the on noise, who devised the code of practice, that acoustic engineer is assumed to make reference to the British Standard, which is in core volume 3 at tab 15, and your lordships have looked at it. And the Lordship's attention has been drawn to the fact that that standard itself cross-refers to the Code of Practice as as a document that specifies a limit. But what it is understood the Court of Appeal had in mind was that the acoustic engineer would get to grips with tables 3 and 4 on pages 113 and 114 of that core bundle. And I don't want to take a great deal of time on this, but the concept that is used is the cumulative lifetime dose of the noise emission level. And it's a logarithmic scale. And what I'm referring to this because my learned friends in their respondent's case make use of this and illustrate how the risk is to be assessed. What you can see is in table 3 is you can arrive at a noise emission level for any level of exposure you like, for any number of years you like. And having arrived at that, you then look at table 4 and look at the risk that's associated with that noise emission level. The difficulty is that this all proves too much. Firstly, there is no stopping point. You can find a risk of some sort at any level of exposure down to 80 dBA. And it needs to be remembered that this litigation started off as litigation attempting to establish liability for any exposure above 80 dBA, not simply 85. And you can arrive, for example, if you go to the bottom line, you can, or if you go to 82 dBA in table 3, after 40 years, someone gets a noise emission level of 98. And you can use that to find that a 60-year-old, as he or she would surely be after 40 years exposure, there's a risk of 5% of such people have a hearing level of 30 dBA averaged over certain frequencies. Now that is a combined noise and age hearing loss. That's made clear by the text. And the point I'm making here is that applying the methodology of the Court of Appeal, we've actually arrived at a risk which appears to be more than minimal in someone who's only exposed to 82 dBA, a half of the energy levels of 85 dBA. And
could you just explain table 4? What's the heading mean? Percentage of persons attaining or exceeding a mean hearing level of 30 dB.
Well, they're given, audiometry is carried out, and at each frequency, they can first hear the beep when they get to 30, what is averaged over those three frequencies.
So it's good, is it, to attain a mean hearing level?
No, that is a loss. We all lose over time hearing levels. And there's a threshold which is actually above audiometric zero, although audiometric zero isn't the same as absolute zero in the sense of no noise.
Anyway, the basic point is that the higher the figures in the table,
the greater the loss.
the greater the loss.
Yeah.
So that 22 is a greater loss than 5, for example. If you're looking under age 60.
No, these are the higher percentages. These are all percentages.
Oh, these are
The
percentages.
level is 30 dB loss.
I see. I'm sorry. These are
And-
percentages. It still follows that 22% of people losing the hearing loss is obviously worse than 5%.
Yeah, yes, one can see that it obviously rises. There's nothing surprising in that. And this is a combined age and noise table. In fact, Professor Luttman, the claimant's expert, said it slightly overstates it for at the lower levels, but that wouldn't have been known at the time. Now, the next point is that the acoustic engineer, who it's posited should have been instructed, would surely not have wanted to stop there. He might have wanted to advise his client, well, what does that mean, a 30 dB loss? And here we have some assistance in the form of the Coles-Wergan tables, which are set out by the trial judge, Core Bundle 2, tab 6, at paragraph 121 on the page after that paragraph. And that there are three descriptive scales of hearing handicap. Because the employer is entitled to know not only what is the risk of something happening, but what is that thing if it happens. And Coles and Worgan were 1977, so just around about the time of the British Standard. And the right-hand column shows that one can have a 30 dB hearing threshold. This is actually averaged over 0.5, 1 and 2 kilohertz rather than 1, 2 and 3. 30 dB hearing threshold, and if one looks at the text, it's either within that bracket, it's either just significant, only slight difficulty with speech and noise, or very slight difficulty with faint speech only, worse in noise. And the footnotes are in brackets. And for example, very slight difficulty with faint speech only, worse in noise, tells that the footnote 5 tells us that at 3 or 4 kilohertz, there can be more than 55 decibels of loss. At paragraph 13 of the judgment, Judge Ingalls had set out a little table prepared by Professor Luttman, in which he identified the expected noise-induced loss at the most sensitive frequency, which is 4 kilohertz, in the most sensitive to noise, in the a number of percentiles, and one sees that the 5th percentile, the worst.
Sorry, paragraph 5.
I'm sorry, paragraph 13. 13. There's a table at the end of it.
Right, yes.
And so one can see that from that table that Professor Luttman explains that exposure of noise for 40 years at various decibel levels, if one takes 85 dBA, the worst 5th percentile of the population group are expected to suffer an 8.5 dB shift due to noise. The worst 5th percentile in the 90 dBA group, 19.3 dB shift. Of course, that could be added to age-induced hearing loss, but if one notes that you can have more than 55 dB loss at 4 kilohertz or 3 kilohertz and still be described as having very slight handicap, slight difficulty with faint speech only, worse in noise, what will have been revealed by those efforts of the notional acoustic engineer is that the membership of the committee who set up the code of practice were clearly conscious of the point at which the risks become at a level at which it was not thought necessary or appropriate to require hearing protection. And the point I'm seeking to make is that if the Court of Appeal say that the employer, the average employer, is not entitled to rely upon the code of practice, but must arrange for his own assessment of the quantum of risk, it really is impossible to know where he goes. He can't expect his acoustic engineer to constitute himself a one-man committee doing better than the Code of Practice Committee. The judge at paragraph 48 of his judgment cites the Wolfson unit at Southampton University, referring to the Code of Practice as a comprehensive damage risk criterion. And that's exactly what it is. In other words, what the Court of Appeal are requiring the average and small employer to do is just to replicate, through the medium of a one-man acoustic engineer, what has already been done by those who know a great deal more about it. But the essential point I'm making is that to go to the British standard doesn't actually give you any anchor points, doesn't give you anywhere else to go other than the Code of Practice. The other point I can make about we have made about the Code of Practice is that when it talks about desirable levels, one needs not to remember that it also refers to noise as having a deleterious effect in respects other than damaging hearing. It can cause distraction and disturbance and so on.
Have you got a reference for that?
Yeah, well, I can. It's core bundle 3. The reference to our
In the Code of
case
Practice.
I think, yes, in the Code of Practice, it's the introduction to the code itself rather than the foreword. At page 1068 of Core Bundle 3. You can interfere with working efficiency by inducing stress and disturbing concentration. And that's a sufficient explanation for the comment that these are not desirable levels, but they're maximum acceptable levels. As far as common law is concerned, from the point of view of the small employer, and indeed the average employer with no special knowledge, the learned judge prepared a very careful and detailed judgment in which he considered all the matters that would be or should have impinged on the mind of the average employer, and came to his conclusion in paragraph 87 of his judgment. And in the Court of Appeal there was a difference of opinion as to what the learned judge was deciding. We make the simple point that to say that any employer, let alone a small employer, should have reacted to a consultation paper issued by the Health and Safety Commission in November 1987, by January 1988, which is before the consultation process was even complete, when it was a consultation paper, and when it foreshadows regulation by reference to a directive which is to come into effect on the 1st of January 1990, to say that that employer has to anticipate that process rather than to prepare in the time given to him to be in compliance with it when it comes into force is wholly unrealistic and is not imposing any sort of common law standard in which the employer is entitled to have his actions judged by reference to prevailing standards, official advice, and so on. And particularly that is so where no one suggests that the European Commission or the Department of Employment had discovered some new risk that no one had appreciated, which had urgently to be dealt with. It was the same old danger, which is that if you expose anyone for long enough, then there is a minority, a small minority, who may be susceptible enough to suffer hearing damage. And so we say the learned judge must have intended to mean that the average employer could wait until the implementation date of the noise at work regulations before he changed his practice, which had up to then had been in compliance with the Code of Practice. or should have been, and let alone that he should have had a higher standard in which he required his employees to wear hearing protection when they're exposed to 85 or above dBA. Because I think with something of a canter, but I am only an intervener, so I'm here, as it were, as a matter of grace. Those are the submissions I wish to make. That's
Thank you very
anything
much.
else I can assist.
Yes, Mr. Williams.
I don't follow.
We'll resume at 2 o'clock. Look forward to hearing Mr. Hendry. Thank you.